Good morning. My name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2020 Harlan Institute Ashbrook Virtual Supreme Court competition. This year, we're arguing the case of Torres versus Madrid, and we're happy to bring you the Elite Eight competition. We have 8 fantastic teams that are mooting. For the petitioners, we have from Creekview, Texas, Brandon and Lisa. And for the respondents, from Connecticut, we have Katie and Leighton. Petitioners, you will have 10 minutes. Begin whenever you're ready.
May it please the court. My name is Brandon Fantine, and I, along with my co-counsel Lisa Frolova, represent the petitioner in today's case. Your Honor, on July 15th of 2014, the respondents, officers Janice Madrid and Richard Williamson, approached Ms. Roxanne Torres, and fearing that they were carjackers, she entered her car and drove off. In an attempt to stop her, the officers began firing at Ms. Torres and her vehicle, where 2 bullets penetrated Ms. Torres' back. Due to these injuries, Ms. Torres had to enter herself into the care of a hospital, putting her in a position in which she could be easily arrested. Roxanne Torres was arrested the next day on July 16th, 2014. Today, we are here arguing 2 points. First is that Ms. Torres was seized the moment she was shot by the respondent under the definition of a seizure outlined in California v. Hodari D. Second is that the aforementioned definition does match the original definition of a seizure under the 4th Amendment.
To address our first point, that an unsuccessful attempt to detain a suspect through physical force does constitute a seizure. The court has defined a seizure using the language of the 4th Amendment several times. However, the most consequential definition was Justice Warren's definition from Terry versus Ohio. This definition, found within the majority opinion of Terry, states that a seizure is the restraint of liberties through physical force or authority. This more traditional definition of how to identify a seizure rests upon a seizure being something that restrains liberties. In the context of the court in Terry, an arrest was considered a seizure because through police authority and physical force, a suspect had his freedoms limited. This limitation on freedoms, or the limitation on what choices a suspect can make, is what constitutes the restraints of liberties prong, found in the definition of a seizure. This definition from...
Counselor, is the definition of a seizure in Terry v. Ohio consistent with the common law definition of a seizure?
Not directly, Your Honor, but in California versus Hodari D, the court further elaborated on the definition of a seizure along with the common law definition of a seizure, where in California versus Hodari D, we see Justice Scalia state that a seizure is defined as being any application of physical force by law enforcement capacity that then, in correlation with Terry, that results in the restraint of an individual's liberty.
That issue wasn't, but what Justice Scalia wrote about wasn't an issue. None of the parties really briefed that issue. I mean, how much weight do we give? I understand holding dicta, whatever, but maybe Justice Scalia was wrong. Even Homer nods every now and then, right? Everyone makes mistakes. Maybe Scalia was wrong on that one.
Well, Your Honor, I wouldn't contend that Justice Scalia was wrong in the context of several different cases, such as in Tennessee versus Gardner. We see how the general understanding of how a seizure is the taking possession of someone or their physical liberties to then apprehend them. The Terry versus Ohio, along with the further elaboration of California versus Hodari D, are both definitions that can be unanimously and universally used upon. They're broad, but yet specific enough to work with almost any circumstances, hopefully. And with that a seizure in the context of an arrest would both be the actual handcuffing or detaining of a suspect, along with any events that directly cause the arrest that involve the use of physical force, as the police actions are limiting a suspect's ranges of choices. For example, in Tennessee versus Gardner, the court unanimously agreed that a suspect was seized the moment that he was shot. Now, because that shooting restricted his freedoms, his range of choices were severely limited, and he had no choice but to submit to the police.
Counsel, I'm having some trouble with just the plain language here. I mean, it's just a plain English matter. How does the word seizure apply to this situation where your client never stopped driving and in fact fled, I think, 75 miles? How do I make sense of that as a plain English matter?
Yes, Your Honor. So the police shot Miss Torres. The question of whether that shot essentially led to a seizure. Without that shot, Miss Torres would not have then been able to, would not have then drove to a hospital to then be treated for those shots. Now, in that moment, it may not have seemed as though that the seizure was successful, but it led to her arrest. Without the police.
But wait a second. Let's say that she never got medical care. She just treated herself like she's a surgeon or whatever. She's amazing. She's a miracle worker. She treated her own shots. Would it be a seizure?
No, Your Honor.
And she was never arrested. She got shot. She drove away. She did self-care and she got away.
No, Your Honor, that then would not be a seizure. We're saying that in the time length of when the police officer shot her, that initially started the seizure. Now, the courts have never really addressed kind of how long a seizure can occur or how long does a seizure last for it to no longer be a seizure. But without that shot and the police ultimately then detaining her, that whole amount of time then resulted in the definition of a seizure and why Miss Roxanne Torres was detained by the police as a result of those two shots. Miss Torres's liberties were, I'm sorry, Your Honor.
It's okay. Counsel, you rely on Terry, and I understand that Terry does explain a definition of a seizure, but that case is widely used for detentions. And in this case, the shooting of the gun and the intention of the officers went beyond a detention. It went to the level of a seizure, so you're arguing. So why does Terry apply if it's a detention case?
Well, Your Honor, Terry applies because it it sets an overall standard that every action that a police officer makes isn't going to be the same for every case scenario, as this is a case scenario that not all police officers have encountered. There needs to be some sort of universally applicable definition that can apply. Now, Terry kind of establishes the base, and with it being further elaborated on in the court of Hadari, we can see that with it being elaborated on to be slightly more specific, we see that it still can be used in today's case as the arrest, and in Terry, the detention was part of the arrest, and that's how the court defined partially what an arrest is and a seizure. And so with that, we can then use Terry versus Ohio in today's case.
I could ask a question to Brandon. Brandon, what if someone, tapped the petitioner on her shoulder? Is that gonna be enough for a seizure in your mind?
Your Honor, if that tapping caused the suspect to submit to police authority, as in stop walking and address the police officer, that would be considered a seizure if the police officer's intent was to detain or
So
arrest.
I tap you on the shoulder and you sort of turn your head like this, just a couple inches, and you keep walking. Is that enough?
Your Honor, the suspect in this scenario has not expressly submitted to police authority. If eventually they do submit to police authority by stopping and being like, "Who touched me?" then that would be considered a seizure. However,
isn't your test really hard to apply because it's very subjective? In other words, your test is not based on the objective intent of the officer. Your test is based on what the suspect does, and suspects are unpredictable. We don't always know what they're going to do. Is that going to make it hard for a police officer to do his job?
No, Your Honor. In the presence of a police officer, a reasonable person would submit to their authority, or in the case where physical force has to be used, they would be forced.
What if they don't
to
know
submit
who
to
it is? They just feel a finger on their shoulder. That's all they know. And the person's undercover. They're not in uniform. In other words, how do we have such a subjective test, where the answer depends on how strong the person is that they can, will they react or not? Isn't that a hard test to apply?
No, Your Honor. Again, this test really mainly hinges on proximate cause and police authority. So even if the person is undercover, as long as they exert some police authority that puts that person in a position where they don't feel free to leave or their liberties are restricted, they have been seized. Now, addressing our second point, the definition from Hodari D does directly line up with the definition of a seizure under the Fourth Amendment. In James Otis's arguments against writs of assistance, he argued how British writs of assistance were inherently wrong and that they restricted his right to life, liberty, and property. So those writs restricted his freedoms. These writs did give police officers the sole power to search and seize. So transitively, the power to search and seize was an infraction on somebody's life, liberty, or property. The definition from Hodari D does directly line up with that, as it incorporates the restrictions of someone's freedoms or their liberty as being a central component of a seizure. Your Honor, it is for these reasons we pray that you rule in favor of the petitioner and reverse the lower court's ruling. Thank you.
Okay, excellent. Thank you so much, petitioners. Petitioners, turn the cameras off, please, and respondents come back on camera. You'll have 15 minutes. Begin whenever you're ready.
Thank you, Your Honor, and may it please the court. I'm Leighton Schur.
And I'm Katie Gutowski, and together we represent the respondent in the case of Torres v. Madrid.
As the counsel for the petitioner has already addressed the facts of the case, we'll move directly into our argument that a Section 1983 excessive force claim grounded in the Fourth Amendment cannot be made in absence of physical control of a suspect, because without physical control, there can be no seizure. And this is established from Brower v. County of Inyo, Terry v. Ohio, United States v. Mendenhall, and Tennessee v. Garner. The case of Hodari D deals with a show of authority at the time when seizure was in question and bears little to no applicability to the case at hand. Instead, we argue that Torres's excessive force claim falls outside the context of a seizure, therefore falling under the 14th Amendment Due Process Clause as established in Sacramento v. Lewis.
So if we look to the earliest examples of when we can determine seizure, as Hodari D dictates, we must look to common law to determine if and where it answers questions of seizure. And traditional common law meaning of the word seizure equates seizure to an arrest, as established in the case of Entick v. Carrington. And we see that Hodari D relies on cases of English debt collection practices in its discussion of the common law meaning of seizure, such as the 1704 case of Jenner v. Sparks, which amounts a seizure to the laying on of hands. And similarly, the 1615 English case of Hodges v. Marks abides by the same standard. However, there are no common law cases that exist which involve a seizure by shooting or through any type of projectile. And
Counselor, isn't that because there weren't really armed police forces with guns? I mean, might that account for the fact we don't have those cases?
Sure, that's true. But all common law seizures that were done through the use of inanimate objects, we see that that's a comparable, that we can draw a comparison there to now. So if we look to the 1604 Countess of Rutland case, you see that this would count as in the same kind of indirect force where the Countess was touched by the end of a mace. That's an inanimate object. But then she submitted in that same moment when she was compelled to be taken to the compter. So in common law, where touch implies this level of physical control, because touching inherently impedes movement or otherwise harms the integrity of the person, a flying object coming into contact with a person's body does not. And as the counsel for the petitioner also distinguishes in their brief, there's a difference between direct and indirect force. And so while common law might establish the Fourth Amendment's protection of the body through direct touch, there are no examples where it provides for the protection from indirect force without submission. And moreover, no examples where the seizure occurred without submission during that exact same encounter as the counsel for the petitioner might argue.
Counsel, I have a question. On page 9 of your brief, you talk about the fact that there's a critical distinction between the words unreasonable and seizure, and you talk about how unreasonable only applies when there is a seizure. Would you agree that the officer's actions in this case were in fact unreasonable, given the fact that she was not the person on their search warrant, she did not meet the description, and they really didn't have any articulable facts to even detain her?
That's a great question. And we first want to start off with the fact that that's not what's being determined by the court at the moment, because to enact the Fourth Amendment, there has to be a seizure. So we're determining if a seizure in fact happened. And secondly, we know from multiple cases that a vehicle is a deadly weapon. And officers are instructed to, they're allowed to use deadly force when their life is in danger or the lives of others are in danger. We know from the facts of the case that she, in fact, started driving a vehicle towards one of the officers, therefore endangering their lives, therefore allowing for the use of that deadly force.
Counsel, I'm struggling with how to draw some lines under your test. So what if Ms. Torres had been shot and it slowed her down, like she wasn't able to depress the accelerator pedal as much, so she went slowly for a half a mile and then she stopped? Would that be a seizure? And if so, at what moment would she be seized?
Well, what we would say to that is that that would not be a seizure. If it's slowing down, there's a difference between slowing down and stoppage, because only stoppage implies that there's a complete control. So if you were driving on the highway and you slowed your speed from 60 miles per hour to 55 miles per hour, that's slowing down. But you wouldn't say that for that reason you'd be under a person's control, even though you slowed down. There would have to be an actual stoppage there. And we see this in the test of Terry v. Ohio, that when an officer, by means of physical force or show of authority, has restrained the liberty of a citizen, but that was determined. Terry v. Ohio was a stop and frisk case, and the restraint of liberty was actually a restraint on movement, because it was determined that the stoppage in that case was the part that created the seizure, unlike the counsel for the petitioner might argue. So this restraint of liberty is really a restraint on movement. And we also see in the Mendenhall test that if, in view of the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. So if you're going slowly, you're still leaving. And Tennessee v. Garner elucidates this further when it says, whenever an officer restrains the freedom of a person to walk away. And so based on all of these three tests, you would say that the freedom of movement such that a person is not free to leave or walk away. And so if you, in that case, if you were still leave, then that would not be a seizure. But if you had even a momentary stoppage, it would be a seizure.
Counsel, I think I understood your opposing counsel in their argument to say that in this case, Ms. Torres was seized by the shots because she was ultimately arrested as a result of them, because she went to the hospital, had to get surgery, and that led to like a chain of events that resulted in her arrest. But that if she had been shot and didn't get arrested, like just got away entirely, then she would not have been seized under the Fourth Amendment by the shots. And if I've understood petitioners correctly, and just let's assume I have, how much does that differ from the rule that you're advocating for here?
So the counsel for the petitioner presents this argument that you just stated, that Ms. Torres was seized when the bullets came in contact with her, but because they limited her freedom of choice when her injuries later required her to seek medical treatment. So the difference between our two arguments is that one follows common law, framers' intent, precedent, while the other is a interesting innovation. The counsel for the petitioner want us to believe that a suspect's liberties are restrained when their freedom of choice is restrained even a little bit. But as my partner stated, these liberties have been clarified, and this liberty that we're talking about is that sufficient intervening act of free will that is defined by stoppage, as we just stated, or not stoppage. So the difference in our argument is that ours provide a clear line. We don't have to look to the events that happen after this encounter, like going to the hospital a day later, instead of just looking to if there was that momentary amount of control being stoppage. And, if we're talking about—
Counsel, let me, if I could jump in, just ask you a question. Let me change the facts, right? Let's say they see Ms. Torres get in her car, and instead of shooting her in the back, they shoot at her tires.
Yes.
And her car comes to a dead halt.
Yes.
Is that a seizure?
Yes, I would say because she was momentarily stopped. So it
okay.
allowed—
Okay. So they shoot her tires, car comes to a dead halt. She gets out, starts running on foot.
Well, I would say due to that momentary amount of stoppage. So the car—
So there was a seizure, her car stopped, she opens the door and starts running. You think there's still a Fourth Amendment seizure there?
Well, yeah, as we talked about, there's that sufficient intervening act of
I mean,
seizure.
come on. How is it possible that you shoot a woman in the back several times? That's not a seizure because she's Superwoman, and then you shoot tires, inanimate objects, and that is a seizure. I mean, I'm having
That's a
trouble with
great
your
question.
rule.
Yeah, no, I love that question actually. So
Me
this
too.
is why basically she's continuously moving in the facts of the case. It doesn't matter what's hit or where she is hit, she is continuously moving. Her movement has not stopped. And when we look to common law, a seizure happens when there is some sort of acquisition of
Right,
physical
but how are we
control.
supposed to enforce this rule? I mean, we don't always have, maybe if there's body cameras, right? But we
Mhm.
can't always do like, super slow-mo play-by-play, was she moving an inch? Was she, I mean, this is a very fact-specific rule that's very tough to apply, I think.
I disagree. In the hypothetical you just gave us, the car stopping for that moment, that there is no way for her to keep driving. That stoppage would be very evident. And I believe that's a very clear rule. She was stopped. She couldn't make that sufficient intervening act of free will, being keeping driving, may or may not give the officers a moment to catch up with her. So therefore, there was stoppage resulting in a seizure. And if we pivot to Brower, I just want to pivot to Brower for a second here, if you don't mind. When we look at Brower, they determined that the reason he was seized was because his car stopped. And I believe the judges has stated that if he hadn't stopped, there would be no seizure. So even if Brower hit that roadblock, his car got destroyed, or he shot his tires and his car stopped moving, and he then got out and kept going, that court would have decided that it was a seizure because they believed that there were two necessary elements to a seizure: acting with intent to acquire control and the acquisition of that control. And they defined that acquisition of control being stoppage.
So does acquisition of control, as you reference on page 14 of your brief, and stoppage, which I'm not quite sure is a word that would be found in the dictionary, but I like your use of it. Are these two things, do they equally apply to the kinds of cases where police officers actually see someone and where they show force, or they have they show their own force, those lines of cases as well, where people are submitting to a show of force?
Yes. I don't want to talk over my partner, but I'll just answer this one more question. So yes, if we look to the case of Brennan v. California, where we see a show of authority, and if we also look to Hadari, the case that's so important right now, where we see of a show of authority, the seizure happened in both these cases when there was stoppage and an acquisition of physical control. So, if we look to the dictionary definitions, if we look to precedent, all the cases that have been mentioned, we see that this factor of stoppage is almost analogous to this acquisition of physical control. So to answer your question, yes.
I have one more question. It seems that your rule would place what happens in the hands of the person they're trying to seize, as opposed to the officer's actions. And is there any precedent in Supreme Court cases or Fourth Amendment cases that put the onus on the person as opposed to the officer?
No, well, to be completely honest, I'm not going to talk about something I'm not sure. There may be cases, there may not, but that's not what's in question here. The fact is that it is still the officers putting the onus on the officer. Because if the officer successfully shoots the tires, the car
Well,
is
then maybe, Leighton, if I can drop and give a question to Katie for a minute. Katie, let's assume maybe you don't have any precedent on point, which is perhaps often the case. I think Justice Peters' question is well taken. Why should we adopt the rules as a matter of policy that puts so much weight on the actions of the suspect and not on the officer? I think it's a policy question, perhaps no precedent.
Sure. Well, I think you have to. I think that again, we would direct you to the goal of seizing, and the goal of a seizure is for the officers to acquire control over a person. That's the state interest of trying to create a seizure. So if you're looking to have the goal of police encounters results in what the state interest is, then you would have to rely on the police officer's control over that person. But that's not to say that this is entirely reliant on those people, on the actions of the suspect, but rather the officer's ability to acquire that control. Just to finish, we would like to recognize that the standard the counsel for the petitioner wishes to set of having this freedom of choice be the determining factor of restriction on liberties, it is not the standard that's set in Hodari, nor is it the standard set in any of a case addressed by the counsel for the petitioner. But the cases of Brower, Brendlin, Garner, Mendenhall, and Terry all provide that stoppage is the indicator of restraint on liberties, not freedom of choice determined through proximate clause. So at the end of the day, the role of this court is to consistently and judiciously apply the law in a way that's consistent with constitutional language, common law, and precedent set by this court. And for those reasons, we urge a decision in favor of the respondent.
Okay, right on time. Thank you, Counselor. All right, we got 5 minutes for petitioner's rebuttal. You can begin when you're ready. Okay, just one of you on camera, both of you be on camera. Okay, there's the other one. Okay, thank you.
Sorry.
That's okay. Whenever you're ready, Counselor.
May it please the court. Your Honor, opposing counsel only used one definition of a seizure, one that required physical control to be exerted over a person for a seizure to be constituted. However, a seizure has been defined in many different ways by the court over the years, so no one definition can be pointed to as the truthful definition unless it matches up with the original definition of a seizure under the Fourth Amendment at the time of ratification. This definition that most accurately lines up with the original meaning during the late 18th century is that of Justice Scalia's from Hodari D, as it involves the restriction of liberties.
Another common law case that redefines a seizure not being the acquisition complete of control would be the case of James Otis's against writs of assistance. A seizure was considered under Otis's impression just a restriction of liberties. Not once did he specify in his argument in this case that the restriction has to be done through a physical acquisition and taking control of someone's life, liberty, or property. All a seizure was a restriction of one of those three things.
The slightest application only applies to police officers in the effect that they can seize or restrict the liberties of a suspect. And a seizure does.
Counselor, if I can interrupt just for a minute, wouldn't your rule make it very tough to be a police officer? Because now when they pull their trigger, their liability hinges entirely on how the suspect reacts to it. I mean, this is sort of the question Justice Peters asked in reverse, right? Wouldn't this make it very tough for cops to do their job? They never know if they'll be affecting a seizure or not, depending who they happen to try to come across.
Well, Your Honor, a big portion of what defines a seizure is the intent of the officer. So if the officer pulls their weapon with the intent to seize, or like our respondent was contending, to stop the suspect, then that would be a seizure if the suspect stopped.
Right, no, but exactly, the intent by itself is not enough. It's got to be intent plus it actually stops them, right? And if we have, your client who's Superwoman who can drive 100 miles after being shot, I sure can't, right? Doesn't it depend on the sort of subjective strength of the suspect? Isn't that a very hard rule to apply?
No, Your Honor. What it hinges on is the proximate cause of the stoppage. So if a police officer's actions did in fact cause the suspect who's fleeing to stop, then that would be a seizure if the intent existed. If their actions did not.
What about a situation where the intent doesn't match up with what actually happened? So for example, what if a police officer touches someone's shoulder with a feather, but unbeknownst to him, the person is powerfully allergic to feathers and she just collapses immediately on the ground. But we have no reason to think that he intended for that to happen because he just touched her with a feather. Is that a seizure or not?
That would not be considered a seizure unless the police officer intended for that feather to stop whoever they were touching and be able to seize them.
What about the fact, though, that she is, in fact, just lying on the ground in police custody?
Well, Your Honor, again, the intent does not match up. So technically, even though there was a show of authority and a restriction on free will, the suspect would not have been seized at that moment because the officer never intended to seize her.
Now, the respondents brought up the momentary stoppage is considered a seizure when the stop is the fruit of a police officer's physical force. Using the respondent's line of reasoning that any stoppage as a result of police action is considered a seizure, Ms. Torres had to be seized when the bullets that the police officers shot at her made her stop driving the car and go attend to her wounds. Your Honor, in any way you cut it, Ms. Torres was seized at one point before she was specifically arrested in the hospital. She was either seized the moment that she was shot that began her restriction of liberties, or she was seized the moment that she had to stop fleeing the police to attend her wounds. The police shooting was the proximate cause of her stoppage. That, with the intent of the police officers to stop her, with her physical liberties being restricted, with the show of authority, and using the definition of Terry versus Ohio, further elaborated on by the Court of Hadari, along with the common law definition, we see a universal definition of a seizure that can be applied to today's case. And with that, it is for these reasons that we pray that you rule in favor of the petitioner and reverse the lower court's ruling. Thank you.
Thank you so much, counsel, for the petitioners and response. If you want to come back on camera, and your teacher as well. Let me be the first to congratulate you. That was really fantastic. I mean, I've been doing this for almost a decade, and it blows me away how 17-year-olds, 16-year-olds can walk in here and perform the work that a law student can do without any hesitation. You four could walk into a law school tomorrow and win a moot court competition. No doubts. You could walk right in. You go to Professor Peters' class and get an A+ in her legal writing class tomorrow. Maybe I shouldn't speak for her. She's a tough grader, but I think you've excelled in ways it's truly remarkable that high school students could do it, and your teachers and coaches have done so much work. It's amazing how easily you parry, right? Where I throw a question at you, say, well, I don't have a good answer to that one, but let me talk about something else. That is so hard to do well. It's such a talent to pivot from a weakness to a strength, because very often the law is not going to be on your side. There's a precedent that is not good for your case. There's some statute or a definition or a dictionary that helps your other side, and you got to live with it. You can't sort of ignore it. You can't dodge it, but you need to work it. I also loved how you responded to your partner on the other side, your friend on the other side. Well, my counselor said this and I said this, and you sort of go back and forth, and that's difficult because you have to do that on the fly. You can't always prepare that in advance. I mean, if you read the brief, that's fair, but they'll say something, she said this, and that's just really useful. Your pacing was good. Your cadence was good. I thought you had authority. You came across as authentic. I didn't feel like you were trying to force it. It felt natural. And I know how hard it is to do an argument on Zoom. And we understand when you're sort of handing off from left to right from your partner. It's not always a smooth transition. You kind of, you still nudge the person in person, but you're on Zoom. You can't do that. But I'm just really impressed with how you've done. This is the Elite 8 round. We've never done multiple rounds before like this. So you're getting better. And I've judged all four of you since the beginning. And I've seen every round you've done, and you've gotten better, stronger, faster, smarter. I don't know how we're going to pick the top two teams. You're going to be separated by just decimals. It's going to be very close. It's going to be hard. And Rebecca, Amanda, any comments you want to give to the students? I'm sure they'll be grateful to hear your wisdoms.
So I teach with Josh Blackman at South Texas College of Law in Houston, and teach legal research and writing in some upper level criminal law classes. I'm a former prosecutor and defense attorney, and joined an amicus brief for this case before the Supreme Court. And so I feel very passionate about this case. But one of the things that I would say is that my students in the first year have to write a brief, they have to do oral arguments, and some of them fear that like all year long, and some of them do quite well with it. But I'm really impressed at this age that you guys are able to do that and do it so well. It was enjoyable to hear your arguments, and I think that you guys handled a very hot bench. You had a lot of questions from the judges, and I think you handled them well. So good job.
Hey, Great job, you guys, like really, really excellent job. I'm not a law professor like Amanda and Josh, so I don't have a whole bunch of law students to compare you to, but from my memory of law school, you guys would totally kill it there. I thought, your presentations were all really smooth. I mean, my job is to argue in court, so I totally know what it's like when you just have to answer a question on the fly and words start coming out of your mouth and you're like, how am I going to finish this sentence? And you all did a great job getting to the end of every sentence coherently and accurately. I also thought, that I was impressed that I think both teams took a slightly creative approach to the legal positions that you had to take in these cases. There are difficult line drawing problems for both parties here. Like, how do we draw the line between what is and isn't a seizure in sort of these unusual fact patterns? And it's hard to answer those questions in a way that sometimes doesn't make you sound kind of crazy. It could be like, no, a touch with a feather is a seizure. Like, okay, that sounds crazy. And so I thought you guys both did a good job of figuring out ways to answer those questions and to draw those lines and to sort of think creatively about the positions here. And then you responded to each other in your arguments really nicely. This is like I know this case well, it's a tricky case. There's a lot of different sources of law here, and I was really impressed by your master and your being able to switch between like the Constitution, the Supreme Court's case law, the common law, plain English language, like really, really great job with that. Overall, really impressed and congratulations.
I do have one suggestion for Leighton. You made me laugh when Josh was asking some really tough questions and he kind of admitted as much. And you said, no, I love that question. It made me laugh. I loved it. Levity in that kind of situation can be good. But when I asked you a question about, the cases and you didn't know the cases, and that's fine. And I'm not even sure that those cases exist. And I think Josh kind of rescued me from that and rescued you from that. But you said, I'm not going to talk about matters I don't know about. And I think the better response would be, Your Honor, I'm not aware of any cases, because you don't want to admit in front of a court that you don't know. Yeah. You're not really aware.
That's what that's what I meant to say. I just came out.
I know. Yeah. But one of the things that would be better that really accomplishes the same goal is just to say, Your Honor, I'm not aware of those cases.
Yeah.
Kind of says the same thing. It's just a little bit nicer to say it that way.
Got it.
Otherwise, I thought you did really well and you handled some really tough questions.
Yeah, and I'll give some similar feedback. When I was a 1L, I had a first year law student. I had a moot court, and I remember I told a judge something like, Your Honor, that's a very good question. He's like, I know, that's why I asked it. And he kind of gave me a little bit of a snarky attitude. So maybe just some gentle feedback to not address the question itself, just sort of answer it. Professor Peterson gave you some really good advice to sort of say, Your Honor, I'm not aware of any such authority, or maybe the closest case I have is X versus Y. One other minor thing, hands, don't do the 1, 2, 3. Don't show your hands should be sort of at the podium or at your side. And on Zoom, it's it's very obvious because it's a little box. So just try to keep your hands. I'm from New York. I talk with my hands. Other things, try to maintain eye contact. Now that's very hard on Zoom, but a lot of you just have your eyes were wandering up and down. Just try to keep your eyes focused on the camera, because the natural human instinct is when you don't know the answer, you start thinking. And when you think, your eyes go up, you don't even realize you're doing it. You'll watch the video later, you'll see it, right? I'll do the clip around on Monday, but just try to keep the eye contact on the bench. And with Zoom, it's hard, right? But imagine you're like Rebecca arguing to the U.S. Supreme Court, which she argued this case, and you have Zoom with the justices, right? There's no camera, but you still have to sort of just pretend you're like looking at them, right? Did you have a prop when you did it? Did you have some sort of prop you were looking at, Rebecca?
No, we're just on the phone. Oh, so we're just on the phone. There's no Zoom, there's no video.
No, but did you have a prop?
Oh no, I had my notes.
Some lawyers actually had 9 photographs of the justices in front of them, and they were actually looking at the photograph to try and see.
Lawyers work at law firms and have
Budgets.
secretaries and budgets to set these things up. In the United States government, it's like whatever I could personally bring myself to the argument. So no.
Funny. That's funny. But anyway, you did so wonderful, and I was interrupting you quite rudely, very deliberately. I'm not a maybe Amanda disagrees. I'm not a rude person, but I deliberately were interrupting you mid-sentence. And then like I jabbed you again mid-sentence. I jabbed you again mid-sentence, like 1, 1, 2, because I want to see how you reacted. And you didn't flinch, right? That is so hard when someone comes at you and starts knocking you off your sentence. Like, God damn, I didn't even finish my sentence. He's already knocking me off one. And I had the, 3-step one, you shoot the tires, you shoot the back, one after I had the entire thing laid out. So that was hard. And it's not easy to pivot so naturally from one to the next. That was just really good.
I think one of the things that Josh did is something that I do in a little more of a gentle way when I'm doing with my students. And that is that oral arguments, when you go to oral arguments, you're there at the invitation of the court, and it's not about you. It's not about your presentation. It's about the questions the court has. And so sometimes what I do is I intentionally move students further and backwards away from what their presentation is. This is such a weird form of public speaking. It is so bizarre because you come with a presentation knowing full well you're not going to get to it all, knowing full well that you're going to be interrupted with questions, and yet you've got to go back to your presentation. It's a really strange thing. And so one of the things that I like to do is I try to get students to move to see if they're willing to move. Because when they're not willing to move, and when they basically tell me, you know what, I'll get to that later, then they're sunk. And so I think that you guys did a really good job of doing that. And I also think that it shows something of your character that you were able to handle that with grace, because it's not really a gracious moment. At least you don't feel like you're under pressure to like perform. One thing that I'll say about Liza and Brandon is it was hard to see whether you were looking at me. It was also hard to judge whether you were reading. And so you had a very smooth presentation, but I think that sometimes it was hard for me to tell whether you were looking at me or you were looking at the screen. And Katie, I think that you are really, really good and you have a beautiful voice. And one of the things that I liked was that you were talking to us, but I think that when you got off script, you would get a little bit nervous. And the truth of the matter is that presentation can become a crutch. But if you think about it as a very intelligent conversation that you've already prepared for by writing the brief, and you guys did a beautiful job with your brief, you can kind of get away from that crutch and realize that I'm just here to kind of have a high level intelligent conversation with judges about the law. And all of you guys were equipped to do that with the research and the preparation that you did. So good job, good job.
I have 2 broad suggestions for everyone in this, and I don't know, these are things that I use all the time in arguments that I argue in the district court, the Court of Appeals, and the Supreme Court, and they're useful across the board and also in the rest of my life. So the first is you just gotta like read the room, and every courtroom is different. And so Leighton, for example, said, I love that question. There are courtrooms in which the judge would love it that you said that, and there are courtrooms in which the judge would be like, And this is obviously we're on Zoom and we're hard to read and we're not real judges, but I thought you guys did a great job within these parameters of reading the room. And there are just, things that are going to be appropriate or not appropriate depending on your level of court and the personalities of the judges you're arguing to. The second is something I use all the time, which is called chunking. So what you want to do is you speak in a few words at a time, and then you move to the next part, and then you move to the next part. And what it allows your brain to do is to catch up with your mouth. And so I use chunking in big meetings. I use chunking at the Supreme Court uniformly because I know that my brain is not fast enough to keep going with this thing. And once I sort of figured out chunking, it's been a huge life skill to me across the board. So for whatever it's worth, that's one of my real verbal tricks. Use it as it helps you.
I've never heard that before. That's actually awesome. That's really, really interesting.
Me neither. I just Googled chunking.
Google it.
I learned something new.
Thank you very much.
Google it. There's there's demos online that give you examples, and you can see someone speaking in a chunking sentence and then not, and the difference, and it really helps me.
Unlike Richard Epstein, we can't all speak in sentences. Not all of us can do that. It's very hard.
Yeah, not unless I pause. Yeah.
I do want to reiterate something Rebecca just said, and that is that you do have to kind of read the court with humor. And usually I do not advocate any kind of humor in oral arguments. When I did oral arguments one time, I was pregnant and I was making a very pregnant and I was making a very plausible argument. It wasn't my best argument, but it was plausible. And when I made the argument, an appellate court, a judge leaned over and said, "You have got to be kidding me." And if I knew the judge well, and if I knew her temperament better, I would have said something to kind of ease the uncomfortable nature of that moment. Like, Your Honor, right now, I kind of wish I were. But I decided to not say that. And that was probably the best thing for me to do. Instead, I pivoted to the reason why I thought it was a plausible argument. And then I moved to an argument that was more plausible. And right after that, I had a judge who threw me a softball because he felt sorry for me in my huge state and in this very difficult, awkward situation. So I do agree with that, that for the humor part, you probably want to avoid it. And I don't know that Leighton meant to be humorous. I just thought I was tickled by it, honestly.
I like.
So-
I thought it was authentic. That's why I didn't mind.
agree.
I thought it was authentic, but it is risky because if you have a tough judge who, like, rah, 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 you know, they get grumpy at this. So it's. I mean, maybe you knew who I am and you felt a little more comfortable. So maybe I'll give you a pass. But it's true. Professor Peters is 100% correct. Every judge, every panel, even the same judge and different panel have a different feel to it, because you know there's interdynamics, especially with Zoom. It's like if I see Rebecca goes off me, I'm like, okay, I'm gonna let her ask a question. All right, I try to defer when the other ones are asking questions, but it's hard to get a feel for a judge. It's if you ever actually when you guys become lawyers one day, which I think a lot of you probably will, if you have an oral argument, go to the court the day before and watch that panel ask questions. Like just watch them. Or now everything's on YouTube. Just watch that judge, watch that panel, and then that will give you a really good sense of where they're going to come at you, because judges tend to be predictable. They have their patterns and their habits. But it's a really good point, Amanda. I think that's fair. I'm sorry to hear the judge was mean to you, but it happens.
So after working with many judges, we would joke that they have something called black robe disease. Not all, but you put the black robe on and you kind of get this God complex. So you learn after a while to tread very lightly around judges. So you guys have questions for us? The last time we asked if you guys had any questions for us.
Please, yes, please. Whatever questions you have, happy to answer them.
This is more of a question about the general structure of this contest. So is there going to be another round? And
I don't think so. I think this is going. We've never done a lead 8 round either. So we're going to have to take the top petitioner, top respondents from these 8, and that goes to the championship. Scheduling another round, there's just not enough time. It takes too many weeks to do it.
Makes sense. Yeah.
The semester is almost over. You guys have your AP exams coming up. And I'm going to tell you the score is going to be close.
Are you averaging the scores across the board?
Yeah.
Wow.
So 3 judges were averaging it, and that's going to be the scores. Just same we did last time. It's going to be real close because all of your teams are roughly evenly matched, which is why I did another round, because I couldn't separate from 24 to 2. So we can do it from 8 to 2, which is a little bit better. Katie, Lisa, Brandon, any questions for us?
I just wanted to say thank you very much. And I apologize. It was kind of hard to see where I'm looking. I tried to make eye contact with one of you, and then I realized that I'm not actually making eye contact with you.
The trick is look at the camera. Don't look at the screen. I know it's almost backwards, but we can't tell which quadrant of your monitor we're looking at. If you look at the camera, it's better. Yeah.
I just so instinctively, I go to look into your eyes to try to read you, and you, but thank you very much. And Brandon, do you have a question?
No.
Okay.
Katie, anything you want to ask us?
No, I don't think so. Thank you, though. This is fun, and to the petitioners, it was very enjoyable debating against you. So
definitely, yeah.
I want to say, Katie, Leighton, and Mr. Smith, I saw you guys in the last round, and I just want you to know, like, I went downstairs and I was like, Ben, my husband, and I was like, you got to hear about these kids and their teacher. They were so amazing. They were like down in the weeds of, Countess of Rutland and the Camelot. And my husband had to hear all about this when I was arguing this case. So he unfortunately knows all this too. And I was like, and Mr. Smith was so on it. And I was just talking about you guys for like a week. So I just wanted you to know.
Thank you very much.
My apologies to your husband.
Like he's been dealing with this for like a year and a half. So.
And now the case is decided, so you can move on to the next one.
Yes.
Awesome. Is there anything else you want to ask me? Or ask Professor Peters or Professor Rebecca?
Before you became a law professor, Did you actually like adjudicate in court? Were you a like counsel for somebody, or did you go
Ask
straight?
Amanda. I only play a lawyer on TV.
Oh, okay.
He worked for a federal court as a clerk, so stop it, Josh. That's a law job. There's a law degree. So we all have different paths. I never expected to be a professor. I wanted to be a prosecutor from the moment that I thought that I wanted to be a lawyer. My dad was in federal law enforcement, and I just heard all these really cool stories about, search and seizures and arrests, and it just sounded so sexy. And so I was like, I want to do that. And
Interesting.
that leading up to that, when I was growing up, I wanted to be a zoologist. And then I got to high school and realized I suck at math and science. I'm allergic to just about every animal there is. So that's kind of a stupid ambition. So my dad always told me growing up, you need to be a lawyer because you don't take no for an answer. And I argued about everything. And so I kind of came to the conclusion that's probably what I should do. So what I would suggest is, for those of you guys that want to do law, think about maybe what you want to do with your law degree. If you want to go to law school, what you want to study in college before you get to law school, and what path you might have. And sometimes the path changes. I was a prosecutor for 8 years in Houston and a defense attorney for 3 years. I came in as a visitor teaching legal research and writing. I love to write. I love to research. And I love teaching. I absolutely love my job. And I think one of the things that drew me to the law and has drawn me to teaching is I'm an idealist. I want to think that what I'm doing makes a difference in the world. And whether it's with a victim or a case or a student. And so I absolutely love what I do, but I did not expect to be here. It was kind of a strange path that I got here. Whereas other people that want to be law professors know well in advance of law school, that's what they want to do. So I would encourage all of you guys who have wonderful speaking skills, research skills, writing skills to consider law for sure.
Thank you very much.
A question. Yeah, I clerked for 3 years in federal court. And I started teaching at South Texas, where Amanda's been teaching now for my entire tenure there. We have some excellent colleagues. But Jeff Korn is judging tomorrow, so we'll have another South Texas face. I was only a law firm, a summer associate. Only time I've actually been kind of a actual law firm. As a law professor, though, I have lots of opportunities to do amicus work. I write briefs. I have some clients that I argue on behalf of, the sort of unpopular ones no one else wants to represent, but I can do those because I have tenure and no one can stop me. But it's truly a blessing. In high school, I did debate. I did mock trial. I was not nearly as good as you were. I could not pull this off when I was 17 years old, not even remotely close. It's just truly remarkable. You should all be proud of yourselves. You could walk into law school tomorrow. I think you all have my email address. If not, I'll put it here. If you have questions for me or Amanda or Beck, I'm happy to forward them on. But this was truly special. And if you're not a senior, hope maybe you can do this again next year, because this competition keeps getting tighter and tighter. And it's going to be very, very tough to pick a winner. I'm not sure how we're going to do it. I really have no clue.
Thank you so much.
Thank you very much. All right, everyone. If any other questions, we'll stop the recording and let you guys off, and the judges can judge and put on our black robes and get God complexes.
Bye. Thank you so much.
Is this like a black robe, man? Does this count?
Nice to have everyone.
Have
Good
a
night,
great
bye.
day.
Take care,
Bye.
guys.
Thank you.
Thank you, Mr. Smith. Thank you, sir.
Bye. Thank you so much.